Hello, everyone. Welcome to today's program, Parental Rights versus Student Privacy, Navigating the Post-Mirabelli Landscape. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speakers, Dr. Sara Young and Katherine Linggi. Dr. Sara Young is a partner at Atkinson, Andelson, Loya, Ruud, and Romo, where she serves as general counsel to school districts and educational agencies, advising on compliance, policy development, governance, instructional programs, employment matters, and conducting impartial investigations, including UCP and Title IX matters. Her legal practice is uniquely informed by advanced academic credentials, including a master's degrees in education and special education and a PhD in educational policy, as well as hands-on experience as an executive director at Capistrano Unified School District, where she focused on special education compliance and informal dispute resolution. Katherine Linggi is an associate at Andelson, Loya, Ruud, and Romo, where she represents educational institutions and school districts in labor and employment matters, general education law, and compliance, with particular expertise in Title IX investigations, trauma resolution, and trauma-informed strategies. She advises clients on a broad range of issues, including discrimination, harassment, retaliation, bullying, and employee misconduct, and is trained to conduct investigations in compliance with California law and federal regulations. We're so excited to hear what they have to share, so I'm going to turn it over to them.
Hello, everybody. My name is Katherine Linggi. Thank you, everyone, for taking time out of your Tuesday afternoon to attend this MCLE about parents' rights and student privacy. I'll let my amazing co-presenter, Sara, introduce herself as well.
It's nice to see you guys. I'm here in the Southland as well, so I hope you're enjoying a beautiful summer day. And I'm happy to talk with you about this topic. It's very timely. We had just these decisions issued, and there's new decisions issued every day about parents' rights. And so I'll talk a little bit about a newer decision that didn't even make the slide when I get to my portion of this, but Katherine's going to get us started with some general parents' rights in education as we lead into kind of our Supreme Court cases.
All right. So as part of our presentation today, we'll walk you through the existing parental rights in the Education Code. We'll discuss the two landmark U.S. Supreme Court cases, Mahmoud v. Taylor and Mirabelli v. Bonta. And we'll discuss some practical implications that arose from these cases. And then we'll have some time for questions and answers as well. But as a general overview, Mahmoud dealt with parents' rights to opt out of material in public school curriculum. And really the main issue that the court answered in that case was, does a public school violate parental religious rights when it exposes students to instruction on gender and sexuality without prior parental notice or the opportunity to opt out of the instruction? So really the key there is parental notice, but more importantly, the opportunity to opt out. And in Mirabelli, the main issue that the court answered was whether a public school violates parents' religious rights and their substantive due process rights when it withholds information from parents about their students' gender presentation at school. Before we kind of jump into the content a bit further, I wanted to define some key terms that will come up a lot over the course of this presentation. So local education agencies, we call them LEAs. It's really just a California public school district, K through 12. Public school administrators are going to be things like your school principals, maybe the superintendent. Certificated employees are just school teachers or other district staff that require a certification. And then pursuant to Education Code Section 210.7, I want to talk a little bit about gender, gender expression, and gender identity. So gender just means your sex. It includes a person's gender identity and gender expression. Gender expression is a person's gender-related appearance and behavior, whether or not this is stereotypically associated with the person's assigned sex at birth. And then gender identity is a person's internal understanding of their own gender. or the perception of a person's gender. So this may include male, female, or a combination of both, neither. It's a spectrum, right? So a gender different from the person's sex assigned at birth is also possible, or transgender, however that person defines their gender identity. Okay, next slide, please. Okay. So cases like Mirabelli and Mahmoud really affirmed parental rights in the educational context. But it's important to note that pursuant to the California Education Code, parents already have a set of pretty expansive rights as it relates to their students. And California Education Code Section 51100 outlines the statutory rights of parents and legal guardians of public school students to be informed about and also participate in their children's education. And it establishes a framework designed to foster a kind of mutually supportive partnership, more or less, between families and educators. So there are other individual sections of the Ed Code as well that include some provisions regarding things like notification, consent, opt-out, parent involvement. But this specific section of the Ed Code is really a key area when it comes to parents' rights. So over the next few slides, you'll see that the Ed Code, specifically Ed Code section 51101, kind of creates a list, right? And it's 16 ways that essentially parents and guardians of public school students have the right to be informed by the school and to participate in the education of their children. And I won't walk you through each one, but just to kind of touch on a few over the next few slides. So parents have the rights to meet with their children's teacher or principal. They have the right to volunteer their time and resources, to receive the results of their child's academic performance. If you can go to the next slide. They also have the right to be informed of their child's progress in school. This is kind of an important one as it relates to Mahmoud, but they also have the right to examine the curriculum materials of their child's class. Next slide, please. They have the right to do things like receive information about any psychological testing the school does involving their child. And they also have the right to deny permission to give that test. They can question anything in their child's record that the parent feels is inaccurate, misleading, an invasion of privacy. So these rights under the Ed Code, they are fairly expansive. However, they're obviously not without limitation, right? If a parent wants to volunteer, they're going to be subject to things like fingerprinting. Being on campus, has to be without disruption. You'll be subject to volunteering rules. Any kind of notification requirement, right, will have to be within a reasonable time. So there are limitations, but overall, pursuant to the Ed Code, parents do have pretty expansive rights already as it relates to their students. Okay. Another existing parental right in the Education Code involves the California Healthy Youth Act, which is enumerated in Ed Code sections 51930 through 51939. Now, under this act, school districts must provide comprehensive sexual health education, which includes information about HIV prevention. And this has to be provided twice. So once in middle school and then at least once in high school. And comprehensive sexual health education includes things like education regarding human development, sexuality, education on pregnancy, contraception, STIs, things like that. You can go to the next slide, please. Great. And so under the Act, parents are allowed to remove or opt their student out from all or a part of this education. But it's important to note that parent consent under the California Healthy Youth Act is passive. So this means that a school district can't require parents to opt into the education, right? However, the district must provide notice to the families at the beginning of the year, basically explaining, these are the educational materials, they're available for inspection by you, and you do have the right to opt out if you choose to do so. Next slide, please. Thank you. Okay, just a couple other general consent provisions of the Ed Code to note before we kind of move on to Mahmoud. Ed Code Section 51513, it requires notification and written consent prior to any type of testing, surveying, where you're asking questions about the student's personal beliefs or practices regarding sex, family, religion, things like that. Or if you're asking them questions about their parents regarding those kind of same topics. Ed Code Section 6614 is kind of similar. Basically just says that you can administer a test or assessment as part of a statewide kind of initiation regarding sex, family life, religion, what have you. And then Education Code 48980 is just the annual notice requirement that school districts are subject to. Okay, next slide. Okay, so transitioning over to Mahmoud v. Taylor. We'll walk through kind of an outline of the next slides on the following slide. Okay, so we'll walk through the background of the case, what the U.S. Supreme Court decided, some impact and considerations to keep in mind, some potential compliance issues for LEAs, and then really what does this mean for LEA students and their parents moving forward. Okay, so turning to the factual background of Mahmoud. So in this case, there was a school district which included LGBTQ plus inclusive storybooks as part of its K through 5 language curriculum. And this curriculum was adopted by the board district-wide. And so these books were specifically designed to bring in a more diverse and inclusive discussion regarding these LGBTQ plus issues like gay marriage and gender identity. So a threshold we like to ask our clients when we're evaluating curriculum and any potential Mahmoud implications is, do you have a board adopted set of curriculum designed to bring in these inclusive topics? If not, you're not squarely within Mahmoud, but there are still several implications of the decision that may still affect you. And so the district initially allowed parents to opt out of this section discussing these books, but what happened is the opt-outs became too burdensome for the district, so they then moved away from that, and they started requiring students to participate in this board-approved curriculum. This upset parents. 3 families filed suit, and these families weren't trying to necessarily stop the books for everyone. Instead, their complaints focused largely on the lack of notice and the lack of ability to opt out. And the reason these families wanted the opportunity to opt out is because they believed that the instruction around these books, this specific curriculum, impacted their free exercise of their religion and also conflicted with their personally held religious beliefs. And the district's response to these suits really relied on this disruption piece and the management issues piece. And they said that these opt-outs caused, a significant management issue. And they also argued that allowing other students to opt out may potentially stigmatize students who do identify as LGBTQ plus in the classroom. So those were kind of their main arguments there. Next slide, please. So the U.S. Supreme Court comes in. They granted a preliminary injunction. And well, some people may say, this is a temporary decision. The majority, when you're kind of reading through this decision, they seem pretty firm in their explanation. So I don't get the sense that they will stray too far on their decision in the future. But in any event, the injunction basically said, you have to stop preventing parents from opting out, and instead you have to go back to at least offering parents the ability to opt out of this specific curriculum. And the court's rationale was really that by requiring elementary school students to participate in the LGBTQ plus storybook curriculum, the district pressured students to reject their own personal or family beliefs that may contradict the message in this curriculum. Specifically, the court found that the storybooks conveyed specific viewpoints that posed, quote, a real threat of undermining the religious beliefs and practices that the parents wish to instill. And the court reasoned that because topics like gay marriage and gender identity were depicted using what they believed was a normative message, they felt that this curriculum was essentially designed to disrupt the thinking of how students, thought or were taught at home about concepts like sexuality and gender. So ultimately, the court found that the district's decision to refuse to provide notice and to also prohibit the parents from opting their children out of this specific curriculum infringed on the parents' rights to the free exercise of their religion and to also direct the religious upbringing of their children. Um, Specifically in this case, the court applied strict scrutiny, although they only really went into that analysis for about a page or so of the decision. But either way, the court found there really was no compelling state interest and that the purpose of the curriculum was not tailored to that specific goal. Okay, next slide, please. So this specific quote we kind of pulled and highlighted because this is the quote from the case and from the majority opinion that we rely on most when looking at opt-out requests and how to fashion subsequent opt-out forms. And the quote says, "The question of whether a law substantially interferes with the religious development of a child will always be fact-intensive. It will depend on the specific religious beliefs and practices asserted, as well as the specific nature of the educational requirement or curricular feature at issue. Educational requirements targeted towards very young children, for example, may be analyzed differently from those requirements for high school students. A court must also consider the specific context in which the instruction or materials at issue are presented. Are they presented in a neutral manner, or are they presented in a manner that is hostile to religious viewpoints and designed to impose upon students a, quote, pressure to conform?" And so when we're doing this analysis, we look mostly at the family's sincerely held beliefs and whether the curriculum really undermines that. And we want to avoid telling families, that belief in whatever religion you are is not correct. This is the belief, or something like that, because the belief is going to be personal to them. It may vary by family. It may even vary by individual within that family, right? So it really is fact intensive. But to avoid kind of an overall free for all, right? You can put the ball back in the family's court or the student's court, and you can create an opt-out form that is set up for them to explain to the LEA, what their specific religious beliefs are and what specific curriculum interferes with that belief and how so. So kind of saying to them, help us understand the connection, and leaning back on them to make that connection for you instead of you kind of taking that on yourself. In reading the majority opinion, though it is likely that the court may allow this connection to be quite broad, regarding, what a sincerely held religious belief is, it can't be as broad as something like, I want to opt out of all LGBTQ plus curriculum. In that case, families will have to justify how all LGBTQ plus curriculum, interferes with their religious beliefs. Instead, we're looking at, what book, what lesson, what specific curriculum conflicts with their belief. Um, and that connection as to why the curriculum conflicts with the belief will also assist the district and the teacher if they decide to provide some type of secondary education plan for the student as well. Okay. Okay, yeah, we're on the right slide. So it's important to note, based off of this quote here, um, the question is not mere exposure. So mere exposure is not the determination here, right? Simply being exposed to LGBTQ plus individuals in the curriculum, like historical figures who may be gay, would not necessarily trigger Mahmoud. Instead, we're looking at whether the curriculum would substantially interfere or pose a real threat of undermining religious beliefs by imposing these kind of normative ideas on the students. Okay, next slide. Okay. Again, Mahmoud is really focused on LGBTQ plus material. However, the decision does not specifically define what constitutes LGBTQ plus related materials. It also doesn't really discuss how to handle the mere presence of LGBTQ plus individuals in instructional material. It's important to note that right now, it is focused on that specific kind of curriculum, but in the future, it may eventually apply to curriculum beyond LGBTQ plus material, depending on its application. And again, when we're reading over the decision, the majority opinion really focused in on and took issue with that kind of quote normative aspects of the storybooks in question. So specifically, regarding same-sex marriage, they felt that the books presented same-sex marriage as not merely an existing practice, but instead they framed it as a perspective that, should be celebrated and positively reinforced, which made, parents feel like it undermined, and the court feel like it undermined parents' ability to kind of present opposite viewpoints. And then regarding gender identity, the court took issue with the book's assertion that at any point in our lives, we can, choose to identify with whatever gender we feel is personal to ourselves. And they felt that the book and the corresponding curriculum presented if the student had a contrary view, that maybe gender was, not as fluid, that was something to be reprimanded for, or kind of looked down upon. So again, they just felt that the curriculum really created these normative beliefs that students were kind of pressured into following. Okay, next slide. Okay, so some considerations to keep in mind. LEAs need to be, aware that there are state and federal laws prohibiting discrimination, and that also provide protections against harassment based on protected characteristics, because LEAs have an obligation to provide a discrimination-free education and work environment. So the overarching principle to kind of keep in mind there is that LEAs must ensure that their curriculum meets all California required standards for students, including any type of curriculum standards that involve anti-discrimination, anti-harassment, things like that. However, if a parent or a student opts out of mandated curriculum based on their religious objections, then the LEA must follow the various opt-out provisions that Mahmoud implemented. Another kind of important caveat here is Mahmoud doesn't discuss what to do if a student is opted out of instruction. So one of the students in Mahmoud, when they had opted out of the curriculum, they just went and they sat in the hallway outside of the classroom during the lesson. But the majority opinion didn't really comment further on those facts and say whether that was sufficient or, yeah, so we'll discuss some other gray areas that the decision didn't fully provide guidance on in a few slides. Okay, next slide. Okay, so what are we kind of looking for when making recommendations of whether Mahmoud is applicable? We're looking at, first and foremost, how is the information presented? Is it being presented in a neutral manner? So, for example, if part of the curriculum discusses Harvey Milk, are we discussing how he was a significant figure in California politics and his role in advocating for LGBTQ plus rights? Or is the curriculum stating, this was Harvey Milk's message and kind of applying pressure to conform to that message? If it's the latter, you may implicate Mahmoud and opt-out rights may be applicable. You'll also want to consider the age of the students. So the younger students, which were at issue in Mahmoud, may require you to kind of take a closer look at whether curriculum requires an opt-out. We find with older students, they may have a better ability to differentiate between what the curriculum is promoting and what their personally held beliefs are, and they may not feel as much of that pressure. Okay, next slide. All right. Some other things to keep in mind when making recommendations to clients are some of the following. So a lot of LEEs or LEAs, sorry, note the administrative burden when implementing opt-out requirements. And kind of as we discussed previously, the majority opinion didn't really seem to think there was much of a burden. In practice, I think we see that there is an administrative burden, but because of the majority's opinion, that may not be a compelling argument, right? When an LEA wants to kind of push back. However, the dissent did kind of note that there would be some disruption because of the opt-out requirements, specifically on student learning and development. And then again, you'll always want to assess what is a sincerely held religious belief? Does the curriculum as written constitute more than just exposure to a topic? Ultimately, does it threaten to kind of undermine religious beliefs of the students in the class? Okay, next slide. So what does this actually mean? How is this impacting LEAs, parents, students? Overall, under the Mahmoud decision, LEAs now have an affirmative obligation to provide parents with notice and the opportunity to opt out of any type of curriculum that may substantially interfere with the religious development of their child. Any challenges under the free exercise clause are going to be fact intensive and fact specific. That's kind of the main takeaway from this. The facts may differ by community, family, age range. If you have clients all over, right, you may see the facts vary a bit. This isn't a one size fits all answer. You'll still have to undergo a fact intensive analysis. And so this is a somewhat gray standard, right? We don't have kind of a bright line standard from the court for notice. We don't have a standard for what opting out, needs to look like, time frame, um, sincerely held religious belief, things like that. So we can take what we have from Mahmoud and kind of give best guidance, but like I said, the decision really doesn't offer a bright line rule on what opt-out requirements and notice will look like. So kind of to look ahead, the exact boundaries of this decision and how it impacts the day-to-day classroom are a bit unclear. But with most issues, right, which are case law kind of dependent, we hope to get clarity through the reasoning that comes from judicial decisions in the coming years.
I will just add on that, bringing it back to what Katherine said in the beginning when she was going over some of what Ed Code says in Ed Code section 51101 in California, which again, we have different laws in other states. It has always been a parent right. I would say always, but in the most recent past, for the time that we can all remember, it has been a right that parents can access the curriculum in their classroom. So, parents have had that ability to go see what their students are learning. In the recent past, if you have a kid in our school, public schools particularly, but a lot of the private schools do this too, your students are learning things that are on Google Classroom. The curriculum is available on the website already. And a lot of districts have a board policy, and board policies are available on websites. 6141.2, which was already a religious opt-out. So it is not a required one. It is a voluntary one, but most school districts in California already had this. And so that was that if there was curriculum happening in your schools that you had a religious objection to, it's where, if there's dissections happening, if there's things happening in your classrooms that you don't want, you would go to your principal and say, this is happening at my school. I saw it in the curriculum. I have a religious objection, a conscientious objection. Let's work through this. You worked through it with your principal. You got an alternative assignment. Where Mahmoud has taken us in California is this notification piece. And so what does notification look like? How do you notify? When do you notify? Is it just telling parents, our curriculum is on our website, here you go? Is it saying, no, you have to tell people at the beginning of a unit? And then how do we address really functionally and strategically in an informed way, in a way that people want their community to be involved? Hey, we're going to be talking about this in class, but we have a parent speaker that came in and brought a book I wasn't expecting. And what do we do with those families who don't want to get badgered and knocked on the door, notified every time? Oh, you're doing a lesson? Well, I don't want to be told about it. It's triggering for me to keep getting notice about this because we like this in our home, or we don't like it and we don't want to keep getting what that might be. And so working through those issues, those opportunities for discussion, that is something that, wasn't thought about by people in robes. And we're having to figure that out. So that's all part of Mahmoud that we're uniquely situated for in California, because we already had a lot of this involvement and rights that just wasn't something maybe people thought about. So I'm going to take you to another case, Mirabelli versus Bonta. So you can go on to the next one. My dream, in case all of you want to know, / my nightmare, is to be the name in one of these. Like, I'm sure Mr. Bonta is whatever, but I never want to be the name on a lawsuit. It's just the name like Young. I hope it never happens. But why are we here? I'm going to give you a little factual background of how Mirabelli versus Bonta made it up to the Supreme Court and is continuing to make its way through our court system today. A little background about the law, the lower court proceedings, the emergency docket appeal to the U.S. Supreme Court, and then the activity that has been happening since then, because it is an ongoing case. And then there are other cases now that are spawning from it, as this case is just continuing to gather traction from a parent rights perspective, but also from a employment law perspective. And so how this is working and what this is looking like for our schools, for our students, and for employees that work in our schools. So why are we here? Go on our next one. Factually, this is two cases that came together But in 2023, there was a school district that shall not be named that adopted a parental notification policy that required certificated employees, which that's any employee that has to have a credential from the state, and administrators who also have to have credentials, to notify parents when they observed students, saw students, learned about students who requested to use a different name and pronoun from their legal name. So if I told a teacher, don't call me Sarah, call me Sean, my teacher was required to call my parent. If my teacher saw that happening on the playground and saw me telling peers to do that, they had to call my parent. Similarly, if a teacher saw a student access programs, activities, or facilities that didn't align with my biological sex, they had to call my parent. So if they saw me walking into a male restroom or a gender neutral restroom that doesn't align with my assumed gender, they needed to call my parent. The policy also required that if I requested, they change information in my official or unofficial records. So ask that they change the preferred name on a document, call my parents. This policy went through their board, got approved, got put up on their website, and Mr. Bonta sued the school district. The state sued the school district. The California legislature then passed AB 1955 in 2023 to be effective that January to prohibit any other school districts from adopting or enforcing similar policies, or policies that would require employees to disclose information about students' sexual orientation, their gender identity, or their gender expression without students' consent. So if a student didn't say, yes, tell my parents, you couldn't tell parents as a staff member. So in response to what was happening, the state came and said, we're passing this. Next slide is actually that statute. So on the next slide, we have what 1955 did, and that added some provisions to the Ed Code. You can read them, they're online. But 20.3 says an employee cannot be required to disclose information about a student's sexual orientation, gender identity, or gender expression to anyone else without the pupil's consent. So my employer cannot tell me to do that. And then the state said, this isn't a change of the law, we're just declaring existing law. And similarly, the next one says a school district can't enforce any existing rule or policy or regulation that requires employees to do this. So again, if you have one, you can't enforce it. That is what 1955 did. So we have this in place. We have the state suing. And then something else happens in another school district. So on our next slide, Escondido down south. They have a gender non-disclosure policy in place. The gender non-disclosure policy that's in place, if you wanted to Google, it is board policy or AR 5145.3. So board policy or administrative regulation 5145.3. It is a non-discrimination policy for students. And in that is language very typically throughout pretty much every district that says, we're not going to tell your parents unless the student wants us to, unless another law requires us to. That's usually what the language says. But in Escondido, it was implemented and enforced a little bit differently, and staff was actually clearly directed, don't tell parents, and also lie to parents. There were some staff members that felt that they were very pressured to be actively dishonest. So it was like, don't tell people, put stickers over kids' names, rip down work from classrooms, be dishonest, deceitful, keep it from parents in every way you can. You know, that's how these staff members felt, very pressured. So 2 teachers challenged the policies on religious grounds, saying, requiring us to use students' preferred names and pronouns at school, and then prohibiting us from disclosing it to parents violates our religious beliefs. So we feel like we're lying to parents. That's against our religion. As a result, some parents and the teachers got together and brought a class action lawsuit. They felt like this was misleading parents or guardians. That is the lawsuit, Mirabelli versus Bonta. It's parents, it's teachers, and they are suing. So that lawsuit is making its way up through California Supreme Court, and we're going to follow it along its pathway here. So initially in December on our next slide, December 22nd, 2025. I feel sometimes it's like when people say, school districts, you did this on purpose. And I want to tell every parent, I guarantee that like transportation did not talk to maintenance, they didn't do anything on purpose. When you get some mean letter from one department on the same day as something else, I'm sure the court didn't do this on purpose, but it feels awful that you like give decisions on Christmas or a decision that's like something on Pride Month or like Black History Month. Like this decision came out the week of Christmas. So on December 22nd, the U.S. court granted permanent injunctive relief to the parents and guardians and teachers about non-disclosure laws. So they said, Escondido School District and State of California, you cannot implement or enforce any provision of California law that would permit or require an employee to mislead a parent regarding gender presentation at school. Can't do it. You also can't require school employees to use a name or pronoun that doesn't match their legal name or their natal pronoun if a parent or guardian has communicated an objection to that use. Okay. And then the state was putting together training materials. Your training materials had to include a statement about parents' constitutional right to be informed about gender incongruence. So this comes down in December. Immediately, the state of California moves for an emergency stay, and the Ninth Circuit Court of Appeals granted that. That was in January. So right after the Ninth Circuit Court of Appeals grants the stay, the parents and the teachers filed the Supreme Court for intervention. And that case was heard by the Supreme Court, and a decision was issued in March. So we can go to that. I think you can skip. Well, we'll go through the next slides. Go ahead. So next slides. This was the actual injunction that was issued by the district court. So defendants, which is again the state and the school district, Escondido, they couldn't have employees directly lie to parents. They couldn't prevent parents from accessing educational records. They could not use different sets of pronouns when speaking to parents than when they were speaking to the kids. So they couldn't kind of code switch intentionally, again, to mislead or lie. They couldn't require employees to use different names or pronouns if the employee didn't want to. They couldn't require employees to tell kids and use different pronouns with kids. And then they couldn't interfere with a teacher or school administrator or counselor or staff member from communicating to parents that a child had been using a different pronoun or name. Next slide. The other part, again, there's a mandatory training that if you work in grades 7 through 12, if you're certificated or credentialed employee working in grades 7 through 12, you have to do a training. The training is about the prevalence of LGBTQ students who commit suicide, who are bullied, your requirement to intervene in those areas to prevent bullying, to be proactive to prevent suicide, some of the laws about facility use, pronoun use, those kinds of things. The state was required to put information about parents' rights in that training. Okay, so case goes to the Supreme Court on March 2nd, 2026. The Supreme Court issues a decision. That's on our next slide. So in that decision, they vacated the stay. So they re-implemented the injunction, but only as to parents, not as to teachers. It's a little complicated, and we're not sure why that is. This is not a surprise, given the Supreme Court, its current makeup, and the other types of decisions it's implementing and issuing right now. So again, like today, the Supreme Court issued a decision about transgender athletes. Not a surprise. Some surprising statements, but not a surprise in it. This one, not a surprise. You have a decision where they said, California's policies, the way they are, substantially interfere with the rights of parents to guide the religious development of their children. They went right to religion, just like they did in Mahmoud. They said, hey, parents are the primary protector of children's best interests. And that's well established, the Supreme Court. The interest of California in advancing student safety and privacy That's what you're saying is your interest in not disclosing and going to what does the child want. That is not compelling enough to overcome the substantial interest of parents in guiding the religious upbringing and the upbringing of their children. So parents, not the state, are the primary authority with respect to the upbringing of their children, the education of their children. And part of that is the right not to be shut out of decisions that involve their children and their children's mental health. They can't make those decisions if they're not informed. Gender dysphoria is a mental health issue. It's a condition that has an important bearing on children's mental health. So if they're not informed about the full aspect of their children, they can't make informed decisions. Part of that is parental notification. So parents need to be part of the discussion, and you can't withhold information. That's part of the underlying theme of Mirabelli. When you continue on, the court says California's policies trigger strict scrutiny. We're using a strict scrutiny standard because they substantially interfere with the rights of parents to guide religious development. So we're going to Mahmoud, we're using strict scrutiny. They're saying, look, we used that over there with introduction of storybooks, but here we're actually talking about kids and their behavior, gender transition, pronoun use. Like, this is a case for strict scrutiny. They also said everyone here, the state, the districts, the teachers, the parents, we all agree that children's safety, overriding issue, what we're all focused on here, and an injunction promotes children's safety by guaranteeing that fit parents have a role in the consequential decisions in children's lives. The injunction permits parents to shield children from unfit parents by enforcing child abuse laws and removing children from parental custody in appropriate cases. So a significant argument used when staff members, district staff want to withhold information from parents is when students will say, and it's true, there's data for this. It's not just, oh, it's anecdotal. There's data for this, that I don't want to tell my parents I believe I will be harmed, whether it's because it's on an extreme, it's going to a conversion camp. Less extreme, it's just a fear of not being accepted. There's some fear of being harmed for a student. If whatever, it's a pronoun use, it's a name change, it's a gender expression and identity fear. The decision tells you, and the way that this kind of rolls out is, if as a district employee, you have a concern that a student is at risk for neglect or abuse, your answer isn't just withhold from a parent. It is, you have an obligation to file a mandated report of suspected child abuse or neglect. That has to go part and parcel. And so if you are withholding, it's because you have filed abuse and neglect report that then is being investigated. That is where they're going, okay, you have fit parents and you have a concern about an unfit parent. We're only allowed to withhold information, under very other circumstances in the state, when we also couple it with the actual report of abuse and neglect that then is investigated. And so they're saying you can't just make this unilateral decision based on nothing. Oh, I'm not going to tell a parent. It's because I am making an appropriate report of suspected abuse and neglect. And we as district representatives, we do hold people accountable for not making unfounded, unauthorized reports. They have to be made in good faith. It's violative of professional standards not to be making those appropriately. The impact of this decision on our next slide is this affected parent plaintiffs, not teachers. So they did not explain why we didn't lift the stay as to teacher plaintiffs, but so much of this is so interconnected. If parents have these rights, teachers have an obligation then to implement things certain ways. There are teacher rights embedded in these, but those have to do with accommodations and supports, and that was not even discussed in this decision. This case absolutely reaffirmed parents' rights. It continued a pathway we're seeing at the Supreme Court level of parents have a right to be informed of and involved in children's educations. Parents are the driver of education public or private. They have a key component in the education system. But this is not a decision on the merits. This case was kicked back, and it is continuing through the court case. So, the nitty-gritty of what the policy is going to look like, what the training on this policy is going to look like, that is all to be worked out. How parent notification looks, what records will look like. All of this has to be kind of tweaked a little bit. And one of the things that really matters in our school system is this is about children. We have a lot of 18-year-olds in our schools. That's in our land of special ed, all of our 18 to 22-year-olds who aren't conserved. But even in our public schools with transitional kindergarten, we see a lot of 18 and 19-year-olds in our high schools right now. This case, this is for students who are under 18. At 18, rights transition to a student themselves. So we're talking about students 17 and below. Okay. So part of Mirabelli recognized parents' rights to be informed about mental health. They focused a lot on gender dysphoria is a condition that has a bearing on mental health. Parents need to be informed. Employee training has to include information about parents' rights to be informed. There is a training, the importance of parents being a member of a school team. We see this a lot, but it really focused on making sure this was explicit. So if you go on CDE's website, you can look up like CDE Mirabelli statement. It's there. It's in bold. It's an exact statement they were ordered to do. It's on a training that people do for Keenan. It's on a training that if you do that I gave, it's there. You're required to have it. Let's see. On March 3rd, CDE came out and issued a statement about Mirabelli. They sent it out to every school district to make sure that all of the districts in the state were aware of Mirabelli, of the Mirabelli decision, of the impact. They made a request. I had a couple slides, sorry. On March 6th, there was a motion to modify the stay that was not granted. So the motion was not granted, the injunction, all of that. We are doing what the Supreme Court said. We are implementing the Supreme Court decision at this point. Just trying to see. I got a little confused by my slides. I apologize. Right now, the way that we kind of explain it to some of our districts is if you are a staff member and you are trying to implement Mirabelli as you were finishing out the school year and you were trying to figure out what to do, as a staff member, you are fundamentally prohibited from misleading or being dishonest or lying to a parent about a student's gender identity or gender expression. That includes pronouns, that includes the name they use. So how that looks in your classroom is when students are using a different name, we don't change their name when we're talking to parents. We don't change their name on our role system, or if we use Class Dojo or Parent Portal. The name we use with kids is the name we use with parents. The name we use with kids is the name we use on our emails to parents, on our communications with parents. And that's how we avoid misleading or, misidentifying or being not truthful or dishonest. If we have parents who then say, wait, you're calling my kid X and my kid is Y, and I disagree and I don't want you to do that, we are now legally required to do the parent's preference. So if you turn around and you go to a kid and you say, hey, I know Sara is your legal name and you really want to go by Sean, but your mom has said, or your dad or your parent guardian, whoever has said, I can't call you that. I have to call you this. Then we're working with our mental health professionals and our other staff to say either let's do some family meetings, let's do some teamwork, or if calling you Sara is causing freakouts and I'm not allowed to call you Sean, your preferred gender, your preferred name, I'm going to call you student. I'm going to call you something that is completely unoffensive. I call all my kids when I was a teacher, dude. Hey, dude. What's up, dude? But we cannot call kids things in conflict with their parents' beliefs once their parents have expressed that to us. And that can be a really hard and difficult conversation. So working through those and working with those. Similarly, we can't hide records. We can't do anything to be hiding and dishonest. But we can work with families and work with our staff to put the most trained, capable person to lead those conversations to get everyone on the same page, because that's what we want. We want everyone to be successful. We want everyone to have a safe school experience and to be the most supported by everyone. There was the last couple slides was the court explaining their rationale, and it is a powerful rationale. If you want to skip ahead to slide 39, when the court was explaining why there is this rationale for, unless you have a child that you believe is actively abused or neglected and you're filing a CPS report and you're moving through that, why do you have to disclose to parents? Why do parents have to be part of this process? And the court said, when the Poe child attempted to commit suicide, had she succeeded, she'd been successful and died by suicide, it would have been the parents who lived with that decision. They were the ones, not Mr. Bonta. Mr. Bonta wasn't sitting at bedside there with that girl. Mr. Thurmond wasn't sitting at the bedside with that girl. The teacher wasn't sitting. The principal wasn't sitting there. And had she succeeded, it wouldn't have been the parents who would have lived with that for the rest of their lives, that they could have done something about it if they had been told ahead of time. So that was why the court made the decision the way they did. And the next slide says at the bottom, those teachers, those administrators, Mr. Bonta, Mr. Thurmond, when the semester is over, those kids are gone. It's not their problem anymore. But for the parents, this continues to be their problem. I might have lots of other feelings about, no, teachers don't stop caring about kids when they're not in their classroom, and we have a lot of feelings. But yes, in a balancing test, I didn't birth that child. It is their child. And that's where the court side is. At the end of the day, this is the person, and this is a family that lives with a decision about whether or not information is shared with them. And so the court erred on the kind of emergency ruling the Supreme Court erred at. We're going to find that this injunction, this day, we're going to do this because this is likely to cause harm if we were to uphold it this way. Now, while the case is decided on the merits, this is what we're doing, and it continues to work its way through the court system. Who knows what the eventual decision will be, how it will shake out, where things will be nitty gritty. If you're familiar at all with California law, you'll know that there's a lot of rights that pass over to kids at 12 about their own mental health, about their own ability to seek medical treatment. Maybe we'll see some things that pass over to 12. I don't know. But right now, absolutely, we tell staff, you cannot mislead, you cannot be dishonest. Parents have a right to be part of their children's education. And we see that throughout the Ed Code. We're just seeing it one more way here in the land of gender. What is unique about Mirabelli, and if you kind of have seen this in the decision, is there is a bifurcation here between gender and sexual orientation. So gender, gender identity, gender expression, all of that is part of the Mirabelli decision, but sexual orientation is not part of it. It's not discussed. That is still a wholly private issue. And part of that is that, that is something we just don't really address that at school. I like to say, like, someone who investigates sexual harassment, please don't do anything sex related at school. It's gross and it's icky. But kids do. And so sexual orientation continues to be a private topic. And so everything we just said about what you need to share with families is really unique to gender, gender identity, and gender expression. It doesn't cross over into sexual orientation. It's 4:59. We've talked for an hour. And we can do a little bit of Q&A, but I do have to run. And so I don't think we have one Q&A in the chat. And it's a good one. Assuming separated divorced parents, and there's one who is happy with gender identity and gender expression, and another who objects, who controls. People have children and they happily agreed at one point, and then they get divorced and they disagree about everything. So if you share legal custody, then it would be no different than if you were married. And if a parent objects, you have to go with the parent who objects. Hopefully we would work through that with all of that happy team bonding. But that would be a time where if both parents have legal custody and have legal rights, an objecting parent would have the ability to stop a process. If not, both parents have legal custody and legal rights, then that would flop all of that over the window. All right. Katherine, anything you want to add? I'm going to hop off, but it was lovely to see you all. So thank you so much for having us.
Thank you, Sarah. And thank you again, everyone, for spending your Tuesday afternoon with us. It was really important that we put this MCLE on the last day of Pride Month to discuss an important topic that intersects with LGBTQ plus issues in the law and also the education sector, which we work in every day. So happy Pride Month. And again, thank you for taking the time to be here today.
This concludes today's presentation. Thank you so much, Katherine and Sarah, for a fantastic presentation today. And thank you to our audience. Have a great day, everybody.